Okay, welcome to part one of trade law, which will focus on the World Trade Organization, which is the primary multilateral institution dealing with trade law and regulation. I want to start by just introducing the different themes. First, we're going to look at trade theory, arguments for and against free trade, and then look at the different types of barrier to trade comprising tariffs and what we call non-tariff barriers, NTBs, and then some historical background. And then I'm going to talk about the Uruguay round, the establishment of the World Trade Organization, and then the rest of the time, pretty much we're going to focus on the various agreements. First, the WTO agreement, and then the various agreements that are annexed to it. Looking into GATS, which is the General Agreement on Trade and Services, the TRIPS Agreement, etc., etc. And hopefully by the end, you will have a good, solid knowledge of trade law. Okay, so let's start with the basics. So what is WTO law? Well, WTO law comprises first and foremost the final act embodying the results of the Uruguay round. And I'll explain later what the Uruguay round is about. And the agreement establishing the World Trade Organization, the WTO agreement. The WTO agreement is actually quite a short agreement. It comprises quite a few, just a few pages. But as they say, the devil is in the details, and all the details are in the annexes. The annexes contain the so-called covered agreements, as we'll see a bit later. But most of the text of WTO law is in the schedules of concessions and the schedules of commitments in the area of services, and I'll explain what I mean by that a bit later on. And then there are the protocols of accession for each new WTO member. So each new WTO member, when they seek to join, they have to go through in very, very long negotiations, potentially with all existing WTO members who are basically admit them to the club on the basis of those negotiations. And those negotiations are embodied in the so-called protocols of accession. And so how long is WTO law in terms of pages? It's over 25,000 pages. Obviously, we have no time to go through every single one of those pages. And we don't have to, because the substantial law is actually much shorter than that, thankfully. There are also supplementary sources of law. And what are these? These are the dispute settlement panel reports and the appellate body reports. Perhaps it's worth mentioning already that dispute settlement reports, which are adopted, and the appellate body reports are part of WTO law, but it's not like a US or indeed a UK sort of common law system. In other words, you don't necessarily set a precedent for other appellate bodies or other panels to follow. So it's not quite like a common law system. In addition, there are declarations and acts of the various WTO bodies, and we'll look at those bodies a bit later, and also customary international law, and also general principles of law, etc. There are also other rules, institutions in international law, which are supplementary sources. There's a so-called Codex Alimentarius, which I'll say something about later on. The World Customs Union had a harmonized quantity description and coding system for tariff classification. I'll explain again later what that is about. And to some extent, other multilateral agreements, including environmental agreements, are likely to be taken into account by panels and appellate bodies, and sometimes they are. So in a way, they are also supplementary sources. And finally, the Vienna Convention on the Law of Treaties. which goes into things like interpretation, how to interpret treaties and their provisions. Okay, so the annexes, and we're going to focus on the annexes. So I don't really think you can see this, but basically here is the WTO agreement. You should download this. All the agreements are available on the website of the World Trade Organization. The WTO agreement is quite short. As I mentioned, it's about 18 pages long. However, it's the annexes, what is annexed to the WTO agreement, which provide almost all of the substantial trade law. And so there's Annex 1, which concerns goods. Multilateral agreements on trading goods. These include GATT 94, the Agreement on Agriculture, and the various other ones as well. You notice that there's one new agreement since 2017, which is the Agreement on Trade Facilitation. Annex 2 is the General Agreement on Trade and Services, or GATS. Annex 1C is the TRIPS agreement, which is on intellectual property. That's rather, like GATS, that's also rather a new thing in trade law. Intellectual property was not previously dealt with as a trade law issue until the establishment of the World Trade Organization in 1995. And then we have the disputes, settlement, understanding, which we're going to look at quite soon because that's incredibly important because, of course, the WTO does provide a mechanism of enforcement, and which is one of the things that makes it new in trade law. And so the DSU is something we do need to look at in a certain amount of detail. And Annex 3 and 4, we won't spend too much time on. The trade policy review mechanism and the plurilateral trade agreements, which are those that WTO members are not required to be parties to. All right. So primarily, we're going to spend the hours on this subject looking at Annexes 1 and 2 to the exclusion, basically, of 3 and 4. So what's good about trade? Might we do well without trading? Well, of course, without trade, we'd all have to be 100% self-sufficient. That's quite a challenge. But in addition, also, maybe we're not able to be self-sufficient. Not just that we choose not to be, or it's efficient to specialize, but also not everything is available. Natural resources, trade in natural resources, if you don't have oil, you can't sell it. You have to acquire it from elsewhere. And to acquire from elsewhere, you have to have something yourself to sell. So trade theory, there has been trade theory going back a long, long time. And it's hard to say what is the right one, what is the perfect one, because every new theory becomes an old theory. But leaving that aside, if we look historically, we can see that the first trade theory as such is what is called mercantilism. Now, mercantilism was based on the idea of really self-sufficiency through control of precious metals, gold and silver. So the more gold and silver you had, the wealthier that you would be. And without that, you are going to be at a disadvantage. How well did that theory work? Well, if you think about Spain in the 15th century, Spain colonized large parts of America, imported vast quantities of gold and silver. You might think, and according to that theory, well, Spain must have been the world's richest country. Well, that didn't really last. That didn't last. Spain, in fact, instead of becoming sustainably powerful and rich, it went into decline surprisingly quickly. Other countries actually benefited from Spain's possession of gold and silver. but not necessarily Spain itself. And in fact, Spain became a poor, rather bankrupt country by the 18th century, and that, of course, lost its empire. So something about this theory wasn't quite correct. It wasn't quite working. In the late 18th century, early 19th century, certain philosophers, thinkers actually it was really in France and Scotland and in England, investigated trade from the perspective of what became known as comparative advantage. And in this scenario, trade was not zero sum. It wasn't, as with mercantilism, I win, if I win, therefore you lose. It's possible that both sides can win from trade. Now, Ricardo came up with this rather simplistic model, which means the real world is nothing like this. But it's nonetheless quite useful in illustrating this particular point that both sides can win from trade. So he came up with this scenario, taking two countries, Portugal and England, and two products, wine and cloth. And he poses the question, well, why would Portugal want to trade with England if it is more productive and more efficient at producing both wine, for obvious reasons? England doesn't really have the right climate for wine, and cloth. Why would Portugal want to trade with England? And the point here is that if Portugal is more efficient at producing wine than it is at producing cloth, even though more efficient at producing both than England, it is to Portugal's advantage to specialize in producing wine and leave cloth to manufacturers in England, and then it can import cloth. So how do both countries benefit? England imports wine from a country that makes it more efficiently, where that actually can produce it. And meanwhile, England is able to make money by exporting cloth to Portugal, and Portugal benefits overall, net benefits, by specializing in wine. Of course, that is, as I said, simplistic, and in reality, it's not really countries that compete, but manufacturers, producers. In short, you might say companies. Those are the ones who are actually producing. And of course, economies are far more complex than producing just two things. Nonetheless, free trade became the orthodox view for quite a long time after that. And of course, free trade sometimes gets criticized, gets attacked, but it always comes back. The idea that reducing trade barriers is best for all sides. After the Second World War, many former colonies became independent. They were liberated, or liberated themselves, and they became independent. When countries became independent, there was hope that suddenly they would prosper, having gotten rid of the colonial masters, the shackles of colonialism. They'd be free to advance and to prosper. It didn't quite happen. What was the reason? Well, one prevalent view was based on the idea of dependency persisting beyond colonialism, after colonialism, and that dependency being related to the closeness, the continued persisting closeness between former colonies and the former imperial powers and other wealthy countries. So it was observed by quite a lot of economists that countries such as those in Latin America, where this theory became quite popular, those countries which exported largely non-industrial products, so commodities, primary products, basically goods that you dig out of the ground or that you grow in fields, the value of these was declining over time in relation to the goods that the rich countries were exporting back. So industrial products were becoming more expensive in comparison to the types of products that developing countries were exporting. So in a sense, it was the closeness of links between countries that was reinforcing the poverty of the, now what we're calling the developing countries. And therefore, it was about breaking those links. So this is quite the opposite of free trade ideology, which, according to which being close together, close trade relations is good for both sides. The dependency theory notion is that actually those close relations between unequal countries just reinforce that inequality. The solution then is to remove that closeness, right? But not just that, is you need to industrialize as well so that you are able to produce high value goods. But how do you industrialize? You have to basically, the idea is that one, you have to reduce your inputs, your imports from the rich countries, except for capital goods, because those capital goods are necessary to accelerate your ability to manufacture efficiently and become more competitive. So in a way, it's import substitution. So you move towards making expensive industrialized goods that presently you are importing. You become self-sufficient in those things. Is perhaps not a view that requires you to be anti-free trade, but to say that free trade can come later, but when we're ready to compete. But certainly, it does imply an ambivalence towards free trade. Free trade is not good at all times between all countries. And then you had the phenomenon of so-called export-led development. So Japan pioneered this, followed by the so-called Asian tigers countries or territories such as South Korea, Singapore, Taiwan, Hong Kong, and then other countries started to follow those, like Malaysia and others. So it was quite a phenomenon originally limited to Asian countries, but now you can see it's happening elsewhere too. So what is export-led development? Well, this is, you could say, a combination of free trade and import substitution. It's a combination of both. So basically what you do is you become industrial producer, and then you export these goods. So you take advantage of low trade barriers in the rich countries while you continue to protect your own domestic market. So take, for example, South Korea. You have these companies that started to become large makers of cars. And they were able to export their cars to North America and to Europe and generate a lot of income that way. In addition to which, they put out lots of trade barriers, lots of sometimes quite imaginative trade barriers, non-tariff, as well as tariff barriers, to protect the domestic market. So with local companies able to acquire economies of scale through having a protected domestic market, they were able to then become quite large companies and could then compete internationally. Of course, from the perspective of some countries, I can think of the United States, they saw this as being as rather unfair in certain respects, and that did have some quite significant implications for trade law, as we'll see shortly. So let's consider the reasons to restrict trade. Why restrict trade at all? Okay, well, one is to protect domestic industry and jobs from foreign competition. So to protect a domestic industry. So the second, somewhat similar, but it's to promote establishment of a new industry. Infant industry protectionism, as it is sometimes called. So one is to protect an existing industry, maybe an industry that's not strong enough to survive free trade in the domestic market. But you may also want to promote a new industry, right? I know South Korea and Japan both started to produce things that they had never produced before. I mean, Korea, for example, would produce pianos. I'm not sure if pianos were ever made before. So a new industry, right? And the way to ensure the industry was able to really take off was to look after it in its early days. So to promote a new industry. So the way that is like a bit like import substitution, but import substitution with a long-term goal to become a successful exporter. So import substitution was not an end, but it was a means to the end, and the end of becoming a more effective exporter. And if you look at that, this idea historically, you see it has quite old roots. So, for example, Alexander Hamilton, one of the authors of the so-called Federalist Papers in the early days of the United States, when it became independent from the British, Alexander Hamilton was a keen advocate of infant industry protectionism, because up to that point, America was a purely agricultural nation. It manufactured almost nothing. And he wanted America to become an industrial country. And that, because at the time, Britain was a world leader in what was called the Industrial Revolution. How to compete with your former colonial master is that you put up tariffs and you stop the British from exporting goods to America. Another was the German Friedrich List in the 19th century. He was another person who believed, and he was a German, so you're thinking here about Germany, that Germany needs, again, also to be protectionist in order to enable it to industrialize. And in fact, he once, he came up with an expression called kicking away the ladder. The idea is that the rich man who climbs the ladder gets to the top and it kicks away the ladder so that nobody else can follow afterwards. So infant protectionism is a strategy to keep that ladder in place so that the poorer countries can climb the ladder as well. You could argue with both these countries, America in the late 18th century and Germany in the mid 19th century, when Germany wasn't actually really a country as such. It was a group of small states. But both those countries did prosper, did become major industrial countries. So you could argue with some historical evidence that in both the case of those two countries, infant industry protectionism did actually work. And as a consequence, the idea that this is a good thing, this is a good strategy, has never quite gone away. And in fact, has in part shaped trade law today, because special and differential treatment for developing countries is in part a reflection of this. It also reflects the fact that introducing complex trade regulations and laws is something that takes quite a lot of time, particularly if you lack capacity. If you're a developing country, you should have more time to implement all these rules. But it is also a reflection of this ideology that industry protection is a successful way to stop economic development from happening in the first place. Another, and this is something I wouldn't want to say too much about, but this was an idea that came up very much in the 1980s. It was a theory that some economists, particularly in the United States, came up with, called strategic trade theory. Now, there are certain industries that are huge industries and costly to set up. And they're so costly to set up that you are never going to have that many companies competing. And the only way it is argued that these companies can exist in the first place and then thrive is a certain amount of protectionism. A good example is aircraft. So if you think about large civil aircraft, it's hard to, well, there are a number of companies, but the ones that are very dominant are Boeing and Airbus. Airbus is a very good example of this because Airbus would not have existed in the first place without massive support from the EU and EU member governments. There would be no Airbus, and Boeing would be completely dominant. Airbus could not exist without protectionism and without massive government intervention and funding. Another industry that's important here is semiconductors. How many countries are important in this industry? A handful, small number. And there will only ever be a handful because of the massive upfront costs of setting up a semiconductor industry. So if you are a country that wants to have an industry in a market where there will only ever be a few players, a few actors, and to keep that industry being successful, then you are it's likely that you're going to have to provide a lot of support that is, in a way, the antithesis of free trade. But that's the only way it can be done. And perhaps in this context, it's worth noting that Airbus and Boeing have often been in conflict. There have been a number of disputes about this because, in a sense, both companies continue to rely on government support in a way that arguably, well, actually not just arguably, it actually is sometimes in violation of trade law. All right. Okay, another reason to restrict trade by certain measures is revenues from tariffs. So tariffs are customs duties. These are imposed at the border when goods cross those borders. They make foreign goods, essentially imported goods, more expensive. Well, that can also be justified by protectionism, but also tariffs do provide revenues for governments. In the developed countries, tariff revenues are not that important compared to other revenues acquired, for example, through taxing income. A percentage of people's salaries are collected by government. And tariffs are a relatively small amount of those government revenues. In some developing countries where taxing income is much harder to do or is not done very efficiently, then tariffs are quite a simple to impose way to collect money, which all governments need to spend on various things that governments need to spend money on. Also for national security, self-sufficiency, safety, nuclear power, steel, food. Well, I mentioned steel there. United States recently put tariffs on steel imports, and it was justified on the basis of national security. A little bit hard to justify, to be totally honest, but sometimes there are reasons to national security reasons, or reasons of self-sufficiency, or you might not want your competitors to have access to some rare product that maybe only your country produces. You may want to reserve that product for your own industry. It might also be during a pandemic, as is something we're going through now. So certain medical supplies, you might want to prevent or restrict the export of these because it is a health emergency and you want to keep these for your own people. The same with food as well during a food crisis. And then they're also to protect or to promote non-economic social values and interests, right? So you may, for example, protect well, not protect, you may restrict trade on the basis of public morals. I mean, you might restrict the exportation or the importation or exploitation of other pornography. Labor standards. Some people may say, well, we don't want to, we don't think our country should import goods made by prison labor or by children in factories. Environment. Some trade in certain things may need to be restrained to protect the environment or to protect animal welfare. And we'll look at that later. There may be concerns about cultural identity, music bans, for example. I'm not saying that's necessarily right or a good thing, and I'm not judging these things, but there are obviously certain non-economic reasons to restrain trade. I mentioned music bans there because when I worked in South Korea back in the 1980s, Japanese music was banned. You couldn't play Japanese music in public. Because, well, at the time, the government was quite anti-Japanese for certain reasons, well, colonialism, etc. And so music was banned from Japan. Just an example. So bans and trade restraints are justified on non-economic grounds. There are also trade sanctions against certain countries. So certain countries that are involved in human rights violations, countries that who have policies that we disagree with. So countries can impose trade sanctions against other countries. In my younger days, South Africa experienced difficulties in exporting their goods because many people didn't agree with the political regime, the apartheid regime, which was, of course, so discriminatory against Black Africans. So how is trade actually restricted? And in short, there are basically two kinds. There are tariffs and there are non-tariffs, right? Which doesn't sound perhaps particularly helpful. So I need to go into a little bit of detail here. So for goods, there are border measures and tariffs. So what are tariffs? Tariffs are otherwise known as customs duties. Basically a tax, usually on imports. And there are three types of tariffs. That's so-called ad valorem tariffs, which is a fixed percentage of the value of a good. So let's say tariffs on importation of sugar. If the value of a ton of sugar is, I don't know, $10,000, then it might be 10% of $10,000. Or it could be a fixed sum added per unit for quantity or weight. It could be 30 cents per ton of sugar or $30 per ton of sugar, right? So it's amount per unit of weight. So 2 tons, then that'd be 60 cents or dollars. Or you can have a mixed tariff, which is elements of both, right? So it could say be 30 cents per ton of sugar plus 10% of the value of the product. So a combination of both. Right. The second type of border measure is so-called quotas, quantitative restrictions, right? So quantitative restrictions, what do we mean by this? It might be that you say we will only import 10,000 cars from Japan per year. This is something that trade law really discourages. It is quite distorting of trade to do this. So it's something that trade law doesn't completely ban, but it is strongly discouraged. Tariffs are not discouraged as such. They are subject to disciplines. The disciplines are set out in trade law. But quotas are rather sort of disapproved of in a way that tariffs are not, right? And then you can have a combination of both, which is tariff quotas. So here, tariff rates depend on a fixed quantity imported, right? And that duty rate, that tariff rate increases as the import quantity elevates above this fixed limit. So you may say, well, we'll export, we will impose a 10% tariff on the first 10,000 Japanese cars, but then that will increase as the quantity of imports goes beyond 10,000. There are also export quotas, right? You may say we are only going to allow this amount to be exported. Why would you do that? Well, it might be reasons of national security. You don't want an enemy nation to have too much of a certain good, or let's say a country you're not particularly friendly with. Weapons, right? Would United States export weapons to Russia? Well, maybe they would export a certain number of a certain kind, perhaps, conceivably. I don't really know. Helping a local industry by assuring local supply and reducing competition, right? Now, for example, China it is one of the only countries, or actually maybe the only country, that is a source of certain what are called rare earths, which are elements that are available only in tiny amounts, right? And can only be found in a very few number of places in the world. But those elements may be very, very important, so-called certain for certain industries. Sorry. So let's think about things like mobile phones, an iPhone. So here an iPhone actually contains inside it a number of very, very rare chemicals, rare metals. And these metals are extremely important for the industry. And China obviously is competing in this industry. And these rare earths, well, yeah, you can understand why China would want to make sure that these unusual elements, rare elements, are at least there's enough there for their own industry before they export them. The thing is that sometimes the reasons given are not completely honest. So protecting natural resources, of course, can be a very good reason to restrict their exportation. But as I say, sometimes things are not done in good faith. The reasons are not necessarily ones given. Excuse me. Okay, that's not coronavirus, I'm sure. And then also responding to requests by a trading partner. Voluntary export requests. Well, these are now prohibited. So, for example, I mentioned about cars, and suppose the United States says to Japan, well, can you please can you please only send us, no more than 10,000 cars? Japan says okay. This kind of sort of collusion here is something that is not prohibited, is not allowed anymore in trade law. Okay, and then 5, there are so-called export tariffs, right? So these are taxes on exports. So done for similar reasons as before, but also for raising revenues. And you can, of course, combine 4 and 5. So you can export quotas and export tariffs. And Chinese actually did that. I mentioned to you before China and the rare earths. So China was actually doing this. And they justified it under the GATT General Exceptions Clause, Article 20, which we'll look at later. But basically, the General Exception Clause allows you to restrict trade in order to conserve natural resources. And so that was China's justification. And this was actually opposed. This was actually there was actually a panel report on this, because the United States complained that China was doing this basically in bad faith. That this was not really to conserve natural resources, but was in fact an unfair trade restraint. Anyway, here is Article 20. This is a very important part of WTO law. It is a general exceptions clause. So, what is this? This matter? One, because exceptions are necessary, and all members would agree that exceptions to the trade rules, which are generally geared towards reducing trade restraints. Sometimes those exceptions have to be applied. They are necessary, as long as they're not arbitrary. Arbitrary means done randomly or without logic, or unjustifiable discrimination. And we'll come back to this clause later on. Okay, so those so I've talked so far about tariffs and other non-tariff barriers, but actually non-tariff barriers, there's actually quite a list of these. So not just about quotas, but also a whole range of different ways that trade is restricted in ways that may be amply justifiable, but sometimes not. And really, in a way, much of trade law is about saying, explaining, and clarifying really where it's okay and where it's not. So the basic definition is obviously any barrier that is not a tariff. So what are these? These are technical barriers, sanitary and phytosanitary measures. So there may be technical regulations, for example. There may be measures to protect plants and animal life and health. These are often completely necessary, but sometimes they actually can't be justified. Lack of transparency in national regulations affecting trade. This does restrict trade. If an exporter isn't fully aware of what are the rules, that can be unfair if that transparency is actually deliberate, and actually transparency itself helps, obviously facilitates trade, so that people know what they need to do to export their goods to another country. Unfair or arbitrary application of national laws and regulations affecting trade. So not just the laws and regulations, but how they're actually applied can be unfair. And then are customs formalities and procedures unduly interfering with trade. What if goods just get stuck on the border? Lots of forms need to be filled in, etc., etc. Well, sometimes, these bureaucratic procedures may be completely necessary, but at some point they become an undue interference with trade, which should really not happen. Government procurement rules and practices. Well, governments may decide that, you know, I know a government that wants to pay a company to supply certain goods. It could be office equipment, it could be medicines, it could be guns, right? Some governments will say we will procure these goods, these services only from national companies, and that's quite normal. Is that is that still permitted under trade law? Yes, it is actually. Yeah, because this is a sensitive issue. So trade law doesn't have much to say, except there is a so-called plurilateral agreement, government procurement. In other words, it's only binding on those countries that actually choose to adopt it, not on all WTO member states. There are also stringent or discriminatory licensing professional qualifications restraining trade. So, for example, if I I have a PhD from university in the UK. Many countries will say, well, a British PhD is equivalent to a PhD in their own country. As far as I know, in France, if I want an academic job in France, I have to have a French PhD. Is that okay, or is that about the trade that shouldn't be allowed? Interesting question. If you qualify as, say, a nurse or a doctor in one country, or a lawyer, are you allowed to practice law, nursing, medicine in another country, or does that country say you have to qualify in this country? That's, again, that may be completely legitimate, or it may be an unreasonable or arbitrary trade restriction. We talk about services. Trade law now does include services. There may also be official campaigns to choose domestic goods over foreign ones. So, buy British, buy American. Is that fair? Is that right? Right. So, if you were to start to think about this, right, you may ask yourself, well, are these always unjustifiable? Are they only sometimes unjustifiable? What are the circumstances that make these acceptable or not, right? What do we mean when we say, well, yeah, I understand why, but it's going too far. You're going too far. What do we mean by going too far? Well, trade law grapples with this subject. And of course, as you might expect, trade law isn't always entirely clear. There is a certain amount of vagueness, which is why panel reports have to investigate the facts of the case and come to some kind of a decision. Okay, so let's go back to the genesis of the World Trade Organization, back to the beginnings. And we really have to start with the Second World War, 1939 to 1945, and the lessons that were learned from that war. What were the lessons? Well, of course, the Second World War really starts in Europe. But the conditions that led to war were partly global as well, right? So in America, the end of the 20s, you had the so-called Wall Street crash. The Wall Street crash, when the share prices, stocks and shares in America hit, they just fell dramatically, and the economy suffered. And as a country that was becoming increasingly dominant globally, this had a massive effect on Europe as well. And so you had a fiscal crisis in United States, in Germany. Germany is important here, and some other countries. How did the United States respond? They passed a law called the Smoot-Hawley Tariff Act 1930, and this was highly protectionist, put up massive tariffs, so America turned its back on free trade, and other countries did similar. And it was hoped that by turning your back on free trade, this would kickstart the economy, which would grow again. It had the opposite effect. It led to the Great Depression, right? Where countries that were growing fast suddenly crashed, and massive problems, fiscal problems, hyperinflation in Germany, massive increase in poverty. And the consequence of this terrible economic shock was that you had political extremism. And so you had Germany, you had the rise of the Nazis, and that led to the Second World War. In 1944, as the war was coming towards an end, America and Britain got together and decided, well, we have to have a plan for a post-war world. And that plan must include three things, right, to respond to the mistakes that were made before that was seen as having led to the war. One, that we must find a way to deal with short-term liquidity fiscal crises where countries suddenly encounter things like stock market crashes, or when the government runs out of money, where you have massive inflation. So these kind of monetary type problems, because when these get out of control, what happens is that countries, the social fabric of countries is torn, and that potentially gives rise to extremist, aggressive politicians taking over, as happened with Hitler and etc. Second is that we need to rebuild destroyed economies quickly, right? We need to lift countries out of poverty as soon as possible. Third, we need to make sure that the temptation to be extremely protectionist is countered by having some kind of an international trading settlement. So I'll go through those briefly one by one. So there was an agreement to establish the International Monetary Fund, the IMF, to deal with these fiscal and liquidity crises. And that was successfully established, and of course still exists to this day. Second, to deal with poverty, including poverty through war, was the establishment of a bank, which is called the International Bank for Reconstruction and Development. Well, reconstruction rather implies that it's Europe that needs help, because Europe was one of the main theaters of the Second World War. It was Europe that needed to be reconstructed, but development was about reaching out to other parts of the world and saying, well, these countries need to grow as well, irrespective of whether they themselves were experiencing that much war. And that, of course, became known as the World Bank. Once Europe was reconstructed, Europe no longer needed help, so the World Bank is now dedicated to helping the developing countries with things like relatively low interest loans for development projects. So I'll say no more about those two institutions. And the third was the attempt to establish so-called International Trade Organization, or ITO. And the International Trade Organization was intended to regulate trade, to discourage unreasonable protectionism, and was to be based on a multilateral agreement. That agreement was made. There was an agreement. So IMF did exist, was established. The World Bank was established. GATT, the Joint Agreement on Tariffs and Trade, was agreed. But GATT was supposed to have been administered by an organization called the ITO. The ITO did not come into being. And I'll explain that in a moment. But first, I want to say something about GATT. Now, actually, I have a copy of GATT here, and you should certainly download it. Here it is here. It consists of 38 articles in Roman numerals. And GATT is important, not just historically, but also because the text of GATT is still part of trade law now, and how that happened, I need to explain to you. So GATT was adopted in 1947, 2 years after the end of the Second World War. Now, the aim of GATT was not to remove all barriers to trade. It was not to remove tariffs. That's not what it was for, exactly. But it was certainly intended to encourage freer trade, right? And how did it do this? Well, GATT was essentially, in the words of the late John Barton and others, GATT was a bargaining vehicle for bilateral tariff-reducing trading, horse trading, as you would say. Horse trading is like barter, what we might call barter in English. So the idea is that it's a forum. Countries come together, so you have, the UK, and you have United States, and you have Japan, Germany, and they come together and they say, well, so Britain says to America, well, we will reduce tariffs on your agricultural produce. The United States says, great, so we will reduce tariffs on tea. Well, not tea, we don't really produce tea, but we do produce tea brands. Other British products we can export to you with reduced tariffs. So this kind of trading. Then Japan may say, well, we will buy more cars from Germany, but on the other hand, in exchange, you want to reduce your tariffs on our rice. And I'm just randomly thinking of examples here. So it's still bilateral, but it's a forum for bilateral. Now, what happens here is that when Japan and Germany agree, or when Britain and America agree on reducing tariffs on each other's goods, that becomes binding on all other countries that have signed GATT. Okay. So the three main principles of GATT are as follows. One is non-discrimination. Now, a discrimination can take place in two ways, right? MFN is most favored nation. What does this mean? Well, the principle of most favored nation is essentially this: you are not allowed, or you are discouraged from discriminating between foreigners, right? In other words, so I'm from the UK. If I make a trade concession to the United States, I have to make that concession to every other country. So this is how you sort of multilateralize the trade advantages you give to one other country. It becomes shared by all other foreign companies. There were certain exceptions, right, to most favored nation. Developing countries get certain benefits, certain advantages that don't have to be given to all of the countries. And there are also certain waivers, exceptions. For example, Britain was still a colonial power, and Britain was provided favors for its colonies that it didn't provide to non-British colonies. And France and Spain, also colonial countries. Portugal would have also given certain preferences for their colonies, and also for their ex-colonies as they became independent. Indeed, there have been disputes where European countries have given continued favors to former colonies that have not been given to other countries. So, for example, there was a case involving bananas, a dispute from Ecuador and the United States against preferences that European countries gave to their former colonial countries, former colonies in the Caribbean. There's also certain preferences which Spain impliedly were given to former colonies that were exporters of coffee. We'll look at that dispute a bit later on. And then there's national treatment. National treatment means you're not allowed to discriminate against foreigners. In other words, you treat foreigners as if they are nationals. So, in short, national treatment means non-discrimination against foreigners, and most favored nation means non-discrimination between foreigners. Best way to put it. So the effect is to multilateralize these bilateral agreements. So GATT provides this forum, this bargaining vehicle for doing this. Second is globalized reciprocity. So in other words, I give you a concession, you give me the same back, right? But then, as I say, that becomes globalized through MFN. Not necessarily, though, for developing countries. So developing countries do not have to give back in equal measure, right? So they're developing countries, but they're also the so-called LDCs, or least developed countries, who they are listed by United Nations. Basically, if you're a developing country, you self-declare, you say, I am a developing country. It's become a bit controversial. Singapore has for long said, well, we are a developing country. And of course, if you've been to Singapore, you know that is absolute nonsense, really, because Singapore is a very wealthy country, wealthier than most European countries, but it continues to claim to be a developing country, and with all the concessions that it gets. I don't think actually they really claim the concessions, but they still call themselves a developing country for the purposes of trade. The least developed countries have even more freedom to not reciprocate in equal measure. Okay, and you can look at the rest of the slide later. Now, the third, special differential treatment is something that, I'd say one or two things about this, but this is treatment for developing and least developed countries, and also actually in recent years for so-called economies in transition, or countries that used to be communist countries that have become sort of capitalist market economies. So, and these are their treatment. So their freedom not to reciprocate in equal measure comes in a number of ways. Is import related, and is export related, regulatory. For example, in the form of transition periods, they're given more time to implement certain norms, and also technical assistance. So they are entitled to get assistance in terms of how to implement trade rules, which of course is not available for the developed countries. And the third is economic liberalism. In other words, what I mean here is that economies are supposed to become more liberal in terms of freeing up trade. So the process towards more liberalism rather than less, right? But there are exceptions, right? And it's worth saying something about these exceptions, not in a specific way, looking at particular trade provisions, but in a more general way. So, for example, Europe and the United States were very reluctant for a long time to include agriculture in trade law. Why? Well, for Europe, there are economic reasons and non-economic reasons. Europe obviously is a very small area of land, and certainly Europe cannot compete in agriculture if it's on the basis of quantity.
Europe can compete on quality, but not on the basis of quantity, with countries having larger land masses, Australia, North American countries, etc. The US also is good at agriculture because they were also, they still do provide lots of support for the agricultural sector. And that support is certainly the antithesis of free trade. Although, of course, the United States is fairly aggressive in terms of exporting agricultural produce to other countries. Another area was textiles. Textiles were also left out again. Well, in England, I work in a city, Leeds, that used to have the biggest woolen mill in the world, and not very far apart is Manchester. Used to be the world's biggest producer of cotton, of cotton cloth and clothes. No longer. So Europe can't compete nonetheless, because these things can be made much cheaper in poorer countries. So there's, for a long time, Europe and the US still continue to want to protect its remaining textile industry, but now it's given up. Right now it's given up, partly because Europe and the US have found other ways to compete, not on the basis of volume, of scale, but on the basis of, well, branding, actually. And we'll look at branding a bit later in relation to the TRIPS agreement. But also developing countries want a certain restrictions on free trade, for the reasons I've given earlier, really, to protect their domestic industries, but also things like food security, etc. They may not want to export all their food and leave none for the local people, right? So developing countries also want to certain, and they still have certain on free trade as well, protect their markets, etc. So the ITO failed, right? It never came into existence. So of the three institutions, IMF, World Bank, ITO, the third one was a failure. So there was an agreement called the Havana Charter, which was meant to establish the ITO, in which would then oversee this GATT, right? And it would provide for one country, one vote, and allow the so-called ICJ, the International Court of Justice, to have oversight, to have legal oversight. This was abandoned in 1951. Why? Because the United States is the one country that has to be a member of this. And the United States Congress didn't want it. Why didn't they want it? Well, it was, I think, to quite a large degree about sovereignty, and the idea of the International Court of Justice having oversight was something that they found not to be acceptable. So what happened? We ended up with an agreement, but without an institution. So GATT 1947 was the agreement. It was administered by the GATT Secretariat, which was based in Geneva. The GATT Secretariat is now the World Trade Organization. But the GATT Secretariat had no legal personality. It had no real power other than to administer this agreement. Nonetheless, starting off with 23 contracting parties, it was a very successful agreement in terms of progressively reducing trade barriers over quite a long time. Well, primarily tariffs. So primary tariff reductions. So you could say even without the institution, it was sorry, I forgot what I was going to say. Yeah, anyway, it was so it didn't come into being, and but GATT itself was quite a successful agreement, and more countries became parties over time. So, and here we get into slightly complex legalities here. GATT 1947 was not directly legally adopted by the parties. So to become a party to GATT, you didn't legally adopt GATT itself. Instead, when you joined GATT, you had to sign the so-called Protocol of Provisional Application, right? And the Protocol of Provisional Application allowed the retention of inconsistent provisions. So although you sign up to GATT, it doesn't mean that your national laws and regulations must be completely compliant with all the articles. You have inconsistent provisions, and those could be retained. Right? I guess that was a pragmatic decision, right? Because if they had to completely eliminate all inconsistent provisions from their laws and regulations, that would have been something that many countries would not have wanted to accept. In addition to which, it was well, you wanted countries to join this, right? But you needed to compromise to enable them to join. Okay, oops. Sorry, yeah, okay. So further liberalization was to be done through trade rounds. So, okay, so countries adopted GATT as a party. They had these inconsistent provisions, but this is not meant to be the end of the process. So a process of progressive tariff reductions and progressive elimination of other trade barriers was to be done through further negotiations over time. And these were called trade rounds, right? And trade rounds, the new trade rounds, of which there were several over the ensuing 40 years, these required the authorization from the United States Congress, which gave negotiating authority to the president. That was well, that's a reflection of how powerful the United States was at the time. And over time, these rounds became more and more ambitious, more and more multilateral, with ever expanded mandates. So more and more things came into discussion. And the last of these GATT rounds was the Uruguay round. And I'll talk a bit later about the Uruguay round. Now, was GATT successful? Well, you could say if the purpose was to progressively reduce tariffs, then you have to say, yes, it was successful. Average tariffs on industrial products fell from 40% to less than 40%. So that was a success, but it also implied that if you felt the need to reduce trade restraints further, then you needed to look in other areas than just tariffs. And this makes things a whole lot more complicated, as we'll see. So, new challenges and new demands. Well, I mentioned before 1960s, the emergence of dependency theory. So the idea that free trade was a good thing came under a certain amount of challenge. The Washington Consensus, they called it, the orthodox view that free trade was a good thing. In the 1970s, there were some crises going on in the form mainly of two oil price shocks. So the oil exporters, particularly in the Middle East, quite dramatically raised the price of oil. And in doing so, it triggered global trade recessions. So trade was hit quite hard. Although, interestingly enough, the impacts were somewhat varied. Japan is not a producer of petroleum, not a producer of oil, and yet Japan seemed to do very well during this time. Japan became, what Japan did in a way was to upgrade its products, the quality. I can remember as a boy, made in Japan usually meant poor quality. And, you know, poorly designed, poor quality goods. In really quite a short period of time, Japanese goods became very, very popular. They became much more stylish and much better quality. So what Japan did was to upgrade its technology and was very effective at doing so. Also a very effective response to oil price shocks. from the perspective of the United States, the United States now found it had rivals, not in relatively large volume, low-tech goods, but at the high technology end. And this was quite frightening for a lot of politicians in the United States. So the US, the technological edge was being quite strongly challenged by countries in Asia and to some extent in Europe as well. But Asia was a new challenge that the United States was not really accustomed to. So countries responded in different ways to this increasing competition and the shock of and the impacts of these rises in oil prices. You had a re-emergence of protectionism and the reappearance of the so-called zero-sum perspective. The zero-sum perspective from the United States was quite important. The United States took the view that instead of free trade benefit, that's all, how come we seem to be losing out, right? We promote free trade, and yet we seem to be importing more and more and more. Our trade balance becomes more and more extreme, or negative trade balance becomes more and more extreme. What's going on here? We need to respond to this somehow, right? So a number of things measures become quite popular here. The use of new tariff and non-tariff barriers to protect local industries, lobby groups, and ensure fair trade. So you start to see the term fair trade used quite a lot these days, rather than free trade. But fair trade becomes a more prevalent term. And you see a greater interest in anti-dumping measures, in countervailing duty actions, which are duties to compensate for dumping. In other words, to make goods that are dumped on your market less competitive by bringing in duties on those goods to make them more expensive. Also, quotas and voluntary restraint agreements. Europeans and Americans getting interested in the idea of negotiating with newly exporting countries to say, can you just restrain your exports to us because we can't, our economies depend on our local industries surviving, and we can't compete for price, and our consumers want to buy your goods because they're cheaper. So these sorts of measures become quite popular, right? So some countries then in this new scenario become more competitive, and those countries that were originally the original leaders are the ones that entered the decade in a dominant position under threat, starting to become much more interested in controlling trade, making trade fair as opposed to free. So you have a number of rather contrasting strategies coming into play. And one thing the United States started to think more about was whether those countries like Japan, followed by other Asian newly industrializing countries, was the idea that these countries, how can they be so competitive in high-tech goods? They must be cheating. They must be stealing our knowledge. And I'll come back to that point a bit later. Right? This can't be fair, what they're doing. They must be stealing knowledge. Of course, to some extent, that was true, right? But sometimes that attitude fails to do credit to the fact these countries themselves had a massive capacity themselves to innovate, right? And the more you try and stop them copying, it's a kind of encouragement to become more innovative, more competitive, rather than less so. By this time, there was more resentment from developing countries towards the protectionism of the rich. So I've mentioned already textiles and clothing. So there were particular trade restricting agreement called the multi-fiber agreement, which highly controversial. It did provide rather too much freedom for the rich countries to restrain trade in textiles from the poorer countries. And of course, this touches a nerve, as we say, for the poorer countries, because well, if you look at history, the countries that start to industrialize, what sort of industries do they start off with? They start off with textiles, producing clothes, and then they start to produce other things, cars and other goods. So it often starts with textiles. That was true of my own country in the 18th century. One of the first big industries was actually textiles. It was mechanized, and cheap labor was a mass production put together made Britain a global leader in textiles for quite some time. And then, of course, the rich countries are not competitive on price anymore or volume. So these Arab countries saw textiles as a step towards industrialization that the Europeans, Americans were really trying to stop in order selfishly to protect the remains of their own textile industries. So in the 1970s, the Tokyo round expanded negotiations to focus more on non-tariff barriers, government procurements, subsidies, technical standards, many of which were applied without transparency, consistency, or logic. So with these different positions of different countries, different responses to differing global trade conditions, this leads to a massive expansion in the mandate of GATT negotiations. And as we see this, the Tokyo round. And then let's go forward another decade to the 1980s. And you have this return to free market economics. Ronald Reagan and Margaret Thatcher are sometimes seen as the architects of this new orthodoxy. So return to free market economists, what's sometimes called by critics neoliberalism. The United States becomes also more aggressive in its trade law in punishing countries perceived to be cheating or to discriminate unfairly against American companies, such as by copying their products. On the other hand, there's also, again, this continuing, persisting anti-globalization actors who say that free trade is harmful and that other countries are hypocrites. Some of these critics are pro-state. They believe that states should not cede power to corporations, or they hold that neoliberalism has harmful impacts on community. It leads to destruction of communities. An example from the United States is that the 1980s, you see, and I went to the US, I went to sort of like Arizona, and then I had a friend who came from Michigan, who came from the area where the car factories are in the Michigan area. And Arizona was part of the so-called Sun Belt of the emerging high-tech economies. So southwestern United States, from Arizona to California, Silicon Valley, these were high-tech technology regions which were actually doing very well. And the northern part of the United States was the so-called Rust Belt, where things like, motor cars, particularly motor cars, America was the world's biggest producer and exporter of motor cars, and then it just could not compete against the competition from Japan and then South Korea and other countries. Germany wasn't able to compete and went into massive industrial decline, which it still persists. It still goes on. So this idea that free trade is very, very harmful to community is of course still persisting criticism. You have, as I mentioned, the technological rivalry of the Asian tigers. There's also a lot of writing in the 1980s starts to appear saying that, countries that are most competitive are countries that that are knowledge-based economies. It's not so much manufacturing, it is knowledge. That knowledge as an input is vital to being a country with a strong economy that's able to compete. Increasing returns to knowledge. How do we increase returns to knowledge? How do we become a knowledge-based property? And this knowledge-based economy, and how do we become knowledge-based economy, and how do we get a bit of edge from being a knowledge-based economy is to stop counterfeiting, stop copying, and use intellectual property laws in order to protect the knowledge addition to your goods that makes them valuable. And obviously that has long-term repercussions in terms of trade law, as we'll see shortly. So after the Tokyo round is the Uruguay round of 1986-94. So here's some context. Tariffs at this point are historically low, and this leads to a shift in new areas for negotiation. Services, because GATT dealt 100% with goods, 0% with services. But services are an emerging tradable commodity, and so why not cover these as well? Intellectual property rights, investment, right? And we need to look more at non-tariff barriers like technical regulation, sanitary measures to protect plant, animal, human life and health. Agriculture. Now we really need to deal with agriculture and textiles, right? Both controversial areas for reasons. Well, I've explained textiles already. Agriculture, I'll need to explain that a bit later on. And this is in the context of US concerns about leakage of technologies, massive trade deficits, a declining share in world trade. As I mentioned, the United States turned to this sort of rather aggressive trade law measure, which actually required the president to impose trade punishments on countries for practices that were deemed to be unjustifiable, discriminatory, or unfair against US industry. And Brazil and South Korea both experienced threats or actual sanctions because they were deemed as being discriminatory against US companies. For example, through not respecting their intellectual property in the way the United States was demanding. So, developing countries, having found that import substitution industrialization didn't work, right? And seeing how certain countries like Japan and Korea had prospered through export-led growth, became much more concerned about market access to markets, particularly the rich countries. Right? So they saw free trade being a good thing if it increased this market access to the rich world, where people have more money to pay for more goods, right? And even for their rather low-tech goods, if they could generate more income from exporting low-tech goods, maybe that it would enable them to upgrade and become more technological in time, producing more high-value but low-volume goods. But there's also arguably an increasing divergence of interest, between developed countries and least developed countries. You have agricultural exporters versus importers. You have economies in transition. You have newly industrializing countries. So you have a divergence of views between countries as to what they want to get out of trade talks. But one thing they all did agree on was that we need to have some kind of system of settling disputes an efficient system of settling disputes. GATT did have one, but it wasn't used that much, and it wasn't especially effective. They wanted to have a more effective dispute settlement system, of course, because every country is equal, right? Every country is equal, whether you are a small country in the Caribbean with a population of 100,000 people, or you are a major country with the United States now 300 million people. Of course, in international law, you are equal, right? So a level playing field, right, that allows each country an equal standing in a dispute, obviously is very attractive to smaller developing countries. So, and whereas the United States and Europe obviously want a strong dispute settlement system of their own interests, they want to stop other countries from, using their intellectual property without permission, for example, and for doing other things, for dumping, etc., etc. So a mutual interest in a strong dispute settlement system. Now, so complex. How do you negotiate with different interests, different types of countries that are net exporters of certain things, countries that are net importers of certain things? Well, it was decided early on that the only way to make the negotiations work was to treat negotiation as a single undertaking. I know what I mean by a single undertaking. Basically, you agree to everything or you agree to nothing. There's no a la carte. You can't pick and choose what you want, right? If you want an agreement on trading goods, then you must accept services agreement or intellectual property. You must accept an agreement on agriculture, even if you don't really like it very much. On balance, you must accept on the base, and you will do because you think, well, we may lose on this agreement, but we'll win overall. So again, it's supposed to be win-win. Everybody gains, even though you have to absorb certain losses. There's certain agreements you don't like, but if people could pick and choose, then that makes for a complete mess, doesn't it? If you think about it. So a single undertaking means you accept everything, or if you prefer, you walk away and do nothing, and you will not become a member of the World Trade Organization. Now, institutionally, at this point, there's just GATT. There's no International Trade Organization. But this is now getting so complicated. Can a relatively small office in Geneva handle something this big, this complex? Well, there was the first thing that everyone agreed was that there will be a ministerial conference. Now, the ministerial conference, what does this mean? A ministerial conference is basically all of the members, all the parties to GATT form a ministerial conference, which would meet every year or every 2 years periodically to make decisions and to including on, what to negotiate in the future, and other things that decision-making bodies have jurisdiction over. So it was agreed to have a ministerial conference, right? And actually, if you look at the WTO structure, I've just got this page here, but you can actually find it on the website. This is the WTO structure now. At the top, the supreme body is the ministerial conference, and below that you have the General Council. You have the dispute settlement body, which actually is the General Council under no name, and you have the Trade Policy Review Body, which is also, the General Council according to what it's called to discuss. So you have the ministerial conference followed by the General Council. That is the hierarchy, right? But the idea was that the ministerial conference would be at the top. That would be at the top. There'd be nothing harder than that. There'd be no global trade organization. So that was agreed quite easily. But Canada first said, well, we need a new ITO, we need a new international trade organization.
And Europe's agreed with Canada. And they had this idea of calling it the Multilateral Trade Organization, the MTO. And that would sit obviously above the Ministerial Conference. That would sit above it, right? The United States didn't like the idea, and nor did the US like the name either. So they didn't like the idea or the name. Again, I guess Congress was concerned about the loss of sovereignty of having a large organization with a legal personality, with the empowered, with a dispute settlement system that may make decisions that be contrary to the United States law. So the United States was initially opposed, but I guess they saw an advantage in having such a trade organization. So the United States opposed first and later agreed, but they insisted one thing, that it be called the World Trade Organization, which I have to say is probably slightly more catchy. World is better than multilateral, which sounds slightly vague and not quite so interesting. And also, the United States insisted that it be given the credit for founding it. So that's politics, all right. So in time, over the course of the Uruguay round, it was agreed that the GATT Secretariat would be upgraded to become the World Trade Organization in the same building. So the staff didn't have to move, but of course it meant for a big expansion. And of course, the World Trade Organization has powers and has jurisdiction much bigger and wider than the GATT Secretariat ever had. All right. Okay, I think I'll stop here and I'll carry on. Part two, we'll carry on with this, but I think I need to stop now because this needs to be uploaded onto YouTube, and this is getting to be a rather large document. So I'm going to stop this now.